We're on the record.
All right, thank you. Good afternoon, everyone. The Appellate Court for the State of Connecticut is now back in session. We will now hear the matter of EICHLER versus Healthy Mom, LLC, docket number AC 43793. I am Judge Mall. I have the pleasure of sitting this afternoon with Judge Alexander and Judge Bishop. Because we are still in the midst of a pandemic, we are conducting this hearing virtually using the Microsoft Teams platform. Before I have everyone state their appearances, let me remind everyone that this argument is being live streamed on the Judicial Branch's YouTube channel. Accordingly, to the extent this case involves any protected identifying information that should not be disclosed, counsel are reminded not to disclose such information during argument. I would now ask that everyone participating in the hearing identify themselves, starting with the judges, then counsel for the appellant, then counsel for the appellee. Again, I am Judge Mall.
Good afternoon, I'm Judge Alexander.
Hi, Bishop. Attorney Bruce Alstein, Goldman, Gruder, and Woods for the plaintiff.
Attorney Mike Cretella from Brenner, Saltzman, Wallman for the defendant, Healthy Mom, LLC.
All right, counsel, prior to this argument, you should have received procedural instructions. Do you have any questions about those instructions?
No, Your Honor.
No, Your Honor.
All right, a few additional preliminaries. When you are not speaking, if you would please silence your microphone, but leave your video on. That will help us ensure that we don't lose anyone. Also, let me state the obvious. When you are not speaking, please try to comport yourself as though you were in the physical courtroom so as not to create any distractions for the court or opposing counsel. Each side will be permitted 20 minutes of argument. I will endeavor to give you a 2-minute and 1-minute warning. The appellant, of course, may reserve a portion of that time for rebuttal. So, Attorney Alstein, are you ready to proceed?
Yes, Your Honor.
All right, you may do so.
Good afternoon. May it please the court. Again, my name is Bruce Alstein. I represent the plaintiff, and I'd like to reserve 5 minutes for rebuttal.
All right, that's fine. Go ahead.
Thank you. This case presents the court with an interesting interplay between the terms of a contract which was breached by a defendant who then attempts to take advantage of a provision in the note that allows it to decelerate and waive certain defaults that occurred. I believe if you interpret the agreement in strict accordance with its terms, which you must, you'll see that the defendant, because of the provision in the note, which requires both the defendant and the requisite holders to exercise a right to decelerate or to waive any default, that the defendant, under very clear contract law stated in Weiss against Smulders, states that you cannot take advantage of benefits that a contract provide when you are in default yourself. Here, my client took all the necessary steps to declare the default in accordance with the terms of the note, gave several opportunities to the defendant to pay. It failed to pay and then commenced action. Only thereafter did the defendant, in concert with other requisite holders unknown to the plaintiff, exercise certain amendments and extension agreements, which my client was not a party to, was not aware of, and didn't sign on to, which the defendant contends forced the notes to decelerate and to waive any default that had occurred. Since that is a benefit that the defendant would be entitled to under the agreement after the default was properly declared, it should no longer be allowed to benefit from that provision. If the court were to rule otherwise, all sorts of mischief could occur. You could have defendants who breach contracts still assert benefits under it. It could extend out to numerous other avenues where there's contracts. If this case were to be cited, even if it were attempted to be limited to the facts, the harm that could come from an interpretation that a defendant in default can still take advantage of the beneficial terms of a contract would turn existing contract law upside down, and I suggest would be bad precedent for the courts to follow. I also talk about the standing argument in my brief about the requisite holders not having been joined here, and that this defendant and this defendant alone does not have the right to assert the deceleration without those others being present, and didn't have the standing to effectuate the deceleration provisions. If the court doesn't have any questions, I will yield my time and rely
Counsel,
on my
I do
brief.
have a question. So the maturity date was originally December 31st, 2015. Is that correct?
Yes.
And wasn't the first extension agreement dated December 30th, 2015?
It was dated as of December 30th. If Your Honor will look in the appendix at page 34, we recite in paragraph 16 that after the demand for payment made by the plaintiff, thereafter the extension agreements were signed. So the default had been properly declared by, and we stipulated to those facts, only thereafter. And they dated the agreement, you'll see, as of a date which always was slightly before the then existing maturity date it contends existed.
Okay, all right. Thank you for clearing that up for me.
Okay. If there's no other questions, I'll rely on my my writing.
All right. Seeing no additional questions, you'll have additional time if you wish on rebuttal. So Attorney Cretella, you may proceed.
Thank you, Your Honor. May it please the court. Just by way of brief background, the defendant Healthy Mom LLC is a company that was established to try to break into the Greek yogurt business. In or around 2014, it sought investors from a number of individuals, which one was the defendant. These several investors each signs or each were given similar promissory notes. They were convertible to equity in the company upon the occurrence of a qualified financing. The company did not obtain a qualified financing prior to the maturity date, and the majority of the holders of this series of convertible promissory notes determined to extend the maturity date. As Your Honor pointed out, the maturity extension agreements are all dated as of the day before the applicable maturity date, but as we stipulated in the facts, some of these extension agreements may have been signed after and then were backdated to the date before. But the ultimate issue here is whether a party can waive a default after it occurs. And it certainly can. There can be a note that becomes matured that is thus waived after a default is declared. And the way these notes are set up, a waiver by the requisite holders is as effective as if the plaintiff itself had waived the default. Meaning if this were just a promissory note between the defendant and the plaintiff, and the maturity date had passed, and the plaintiff said, I'd like to give you another year to try to pay off this note, nothing would have prevented them from, after an event of default had occurred, from entering an agreement stipulating that the maturity date is going a year in the future and that any prior defaults are waived. And the way these notes are set up, such a waiver by the requisite holders, as they're defined in the notes, is the equivalent to a waiver by the plaintiff. And the plaintiff knew this. He signed or he was given a promissory note with these specific terms in it. There's no argument that the terms are unclear, but it appears the plaintiff is just trying to get out of a deal that he freely and voluntarily made. And under applicable Connecticut law, the courts have an obligation to enforce contracts as they're written. There's no claim that this provision is unconscionable or otherwise unenforceable. And these types of provisions are common when there's early stage startup companies seeking investors. The investments do not work if the defendant is permitted to take his share back prior to the other investors. And if you look at paragraph 10 of the note, it specifically says that all of these notes rank pari passu as to the payment of principal and interest. And it also says that the plaintiff agreed in that provision that any payments to the plaintiff or to any other holders of the notes, whether principal, interest, or otherwise, shall be made pro rata among the holder and other holders. Meaning the note itself says that the plaintiff is not going to get paid back until everyone gets paid back. And the defendant, Healthy Mom, is not entitled to pay plaintiff his share of the outstanding aggregate amount of these Series B notes unless it also pays all of the other requisite holders. And the way this investment was set up, all of the requisite holders are in the same boat, and they're all subject to payment at the same time. They're all subject to the same default provisions and waiver provisions. And in this case, under the specific terms of the note, the majority of these requisite holders determined that it was in their best interest to extend the maturity date and to waive any defaults that had occurred. And once the majority of the requisite holders determined that it was in their interest to do so, the defendant, although he may not like it, he is bound by that determination of all the requisite holders. So I disagree that enforcing the note as it was written and as Judge Avalone correctly did in the trial court would somehow open Pandora's box because in this case, it's a very specific note. And all we were asking, and all the trial court did, was enforce the note according to its express terms. I don't think the defendants have cited any case law, or I don't think the plaintiff has cited any case law that stands for the proposition that a default cannot be waived after it occurs. This seems, in my experience, relatively commonplace for parties, for one reason or another, to enter into agreements after a default has occurred as to their respective obligations going forward. The one case that was mentioned in counsel's initial argument was this Weiss case, and the plaintiff characterized that case as precluding the defendant from getting the benefits of a contract. But Weiss isn't about the benefits of the contract. Weiss is about the proposition that a material breach by one party discharges the other party's subsequent duty to perform on the contract, and that's at pin site 263 of Weiss. That is different than saying that the defendant's failure to pay the note when it's due does not allow the defendant and the requisite holders, or the defendant and the plaintiff, should the plaintiff have desired that, to enter into a waiver or a modification agreement. We're not asking the plaintiff to perform some obligation under the contract, and Weiss is completely an opposite on that point. With respect to standing, standing is the right to set the judicial machinery in motion. We're the defendants here. The plaintiff brought an action against us that we defended on the basis of undisputed, stipulated facts that the requisite holders entered into these extension agreements, excusing any default and modifying the maturity date. I don't think standing is at all at issue with respect to our special defense on that basis. So overall, I would implore this court to affirm Judge Avalone's well-reasoned decision. I would implore this court to hold that the parties should be bound to the terms of the agreement that they entered into, and that there is no reason for any court to second guess the deal that the plaintiff voluntarily entered into. If the court has any questions, I'd be happy to answer them. Otherwise, I would rest on the remainder of my brief and thank the court for its time.
All right, thank you. I see no questions from my colleagues. So Attorney Elstein, you have a little over 15 minutes.
Okay, thank you. The provision in the note, which is paragraph 10, has a subparagraph B. And the subparagraph B is what they're relying upon in this case, what the defense is relying upon as the ability to waive or modify the terms of the note. And it's interesting because that provision says, upon, quote, upon the written consent of the company, which is the defendant, upon written consent of the company and the requisite holders. So the company has to affirmatively get the benefit of that provision when it is in default. That is the harm that we have here, where the defendant is attempting to take advantage of and should not be allowed to because of its prior material breach of the provisions of the note. And so when I talk about the benefits being relieved, it's the benefit that my client no longer has to provide the defendant in giving that provision of the note life. He is relieved of the obligation of providing them that ability to decelerate because the defendant itself must participate with it. With respect to the pari passu argument, I think that's a red herring. Whether the company will be required to pay off all note holders or my client alone will be determined down the road after we have an enforceable note upon a reversal by this court of the judgment by Judge Avalon. Unless there's any other questions, I'll rely on my brief.
All right, seeing none. All right, thank you, counsel, for participating in this virtual hearing. We look forward to being back in the physical courtroom, hopefully next term. And the court will now be adjourned until Monday, April 19th at 9:30 a.m. Thank you.
Thank you.
Thank you.